Welcome back to another video, and this is part 3 of the duties of trustees. So let's get straight into it. There's also a duty on the trustees to take professional advice when required, and we have this quote from McGarry, Cohen and Scargill from 1985 that says, "That duty includes the duty to seek advice on matters which the trustee does not understand, such as the making of investments, and on receiving that advice to act with the same degree of prudence. This requirement is not discharged merely by showing that the trustee has acted in good faith and with sincerity. Honesty and sincerity are not the same as prudence and reasonableness. Some of the most sincere people are the most unreasonable, and Mr. Scargill told me that he had met quite a few of them. Accordingly, although a trustee who takes advice on investments is not bound to accept and act on that advice, he is not entitled to reject it merely because he sincerely disagrees with it, unless in addition to being sincere, he is acting as an ordinarily prudent man would act." So in this particular case, the defendant Scargill was the president of the Mine Workers Union and a trustee of the Miners' Pension Fund. And the Miners' Pension Fund had an investment plan which included investments in South Africa and into the oil industry. Scargill felt that investing the Miners' Pension Fund in oil companies, which were in direct competition with the coal industry, was not in the beneficiary's best interest. He therefore proposed that the pension fund withdraw its investments in this area and also divest itself of its South African investments on political grounds, as the apartheid was going on at that time. In other words, Scargill, despite the investment plan, did not think that it could possibly in the best interests of the members of the Miners' Pension Fund to invest into South Africa or the oil industry. And it was held that a trustee had a duty to maximise the return on the fund he was administering, and that it was not up to the defendant, Scargill, to reject the investment advice on the basis that he had a political, ethical, or personal objection to the investment. So if the advice, as it was here under the Miners' Pension Fund, was that South Africa and the oil industry were good investment opportunities, then Scargill could not disagree with that advice on the grounds that he had some sort of objection to investing in these areas. So Scargill lost the case. He had to take the advice from the Miners' Pension Fund investment plan. Now, the Trustees Act 2000, Section 5 requires that trustees obtain and consider proper advice about the way in which the trust should be invested. So this duty to take professional advice when required is now statutory. It doesn't say obtain and follow in the statute, but it says to obtain and consider. So it's not actually binding on them. They don't have to follow the investment advice, but the onus would be on them to come up with a reason why they shouldn't follow the advice. There is an exception for when the trustee reasonably considers that advice is unnecessary. This means that trustees must take professional investment advice unless the amount at issue is too small to be worth the cost, or the trust instrument requires that the property is kept in a particular form, such as property or shares in a family company, or if the trustees reasonably believe that they have the requisite skill. So trustees don't have to take advice where they reasonably, objectively consider that advice unnecessary. So prima facie, they have to consider advice, but this is a situation where they don't have to consider the advice. So generally there is a duty to take advice before investing in the trust property, but if they reasonably consider that advice unnecessary, then they don't have to. And the next duty we're going to look at is the duty to avoid conflicts of interests. So the fiduciaries are also obliged to refrain from any potential as well as any actual conflicts of interest. So you cannot put yourself in a position of potential conflict. In Keach and Sanford from 1726, Lord King says, "Although I do not say there is a fraud in this case, yet the trustees should rather have let the lease run out than to have had it to himself. In other words, he should have let the lease expire. It may seem hard that the trustee is the only person of all mankind who might not have the lease, but it is very proper the rules should be strictly pursued and not in the least relaxed, for it is very obvious what would be the consequence of letting trustees have the lease on refusal to renew the SDK use. So this is the leading case here, and that quote may be a little bit confusing, but let's have a look at the case itself. So this is about a family property, so it's about land in the form of a leasehold, which had been left in trust for an infant. Mr. Sanford was entrusted to look after the property until the child matured. The lease subsequently expired and the landlord refused to renew it for the infant because he was an infant and couldn't be sued. So the trustee renewed the lease in his own right. He saw it of good value and good investment and bought the lease for himself. When the infant, who was now Mr. Keach, grew up, he actually sued Mr. Sanford. And the court held he shouldn't be able to have the property. So the property was held on constructive trust for Keach. So the court is being, and always has been, hardcore on conflicts of interest here. In this case, a trustee sought to renew a lease which previously he had held on trust for the infant beneficiary Keach. Okay? So the beneficiary, being an infant, was not able to take out the new lease in his own name, and therefore the trustee was taking the lease out in his own name instead. So it was held that the lease should be held on a constructive trust for the beneficiary, not because there had been any suggestion of fraud or unconscionable behaviour on the part of the trustee, but rather because the court considered that it would be astute to prevent even the possibility that there might be an unconscionable benefit taken by a trustee. And it functions in Lord Herschel's account on the basis of a maudlin attitude to human nature, by which it is supposed that all people, whether fiduciaries or not, are weak and will succumb to temptation if the law is not pitched at its strictest. Okay. We've got this quote there from Lord Herschel, which is, "It is an inflexible rule of a court of equity that a person in a fiduciary position, such as the respondent's, is not, unless otherwise expressly provided, entitled to make a profit. He is not allowed to put himself in a position where his interest and duty conflict." So this is just reiterating this point. Trustees have a duty to avoid conflicts of interest, or more generally, fiduciaries have a duty to avoid conflicts of interest. And this is a case that comes up time and time again, Boardman and Phipps, and I would recommend you reading the case properly. But I'm going to go over it again because it's very important with regards to conflicts of interest. So this was a breach of fiduciary duty and not trustee duty, because the solicitor was not a trustee, but he was in a fiduciary relationship to the trust in question. And in some cases, it appears to operate harshly, where trustees appear, or they seek to make a profit for the trust, which the beneficiaries acting through the trust could not have made for themselves. And that's what's seen here. So this particular situation does seem pretty harsh, but it shows how strict the court is in upholding fiduciary or trustee duties. So Boardman was a solicitor of a family trust, and the trust assets included a 27% holding in a textile company, and this was the largest single shareholding in the company. And by virtue of his position in relation to the company's largest shareholding, over a period of 18 months, Boardman was given access to a large amount of commercial information relating to the company's business, which was not in the public domain, including detailed accounts as to the turnover of the company's various factories. This information was treated as being confidential, as in correspondence between the directors of the company and Boardman. Boardman was concerned with the accounts of the company and thought that to protect the trust, a majority shareholding is required. So, armed with all this information, he hit upon the idea of asset stripping the company so as to increase the value of all the shares in the company. Boardman realised that the company was undercapitalised and badly run, and believed that with an injection of capital, change of management and restructuring, this could be a very profitable company. And because the company was a private company, Boardman would have been unable to find out this information or to acquire shares in the company but for his role in relation to the trust. So to carry out his plan, it required that the trust acquire a majority shareholding in the company. And the trust was not able to acquire the extra shares itself, both because the trustees did not consider the trust was insufficient funds for the purpose, and because the trust would have required the leave of the court to make such an acquisition. Therefore, Boardman and one of the trustees, Fox, decided to acquire the shares personally, with Boardman contributing a fair amount of his own money here. Boardman informed the active trustees he intended to do this. However, it was held that Boardman had not provided them with enough information to be able to rely on the defence of their consent to his plans. Their shareholding combined with the trust shareholding meant that Boardman and his trustees could in effect control the company. With a great amount of work on Boardman's part, the company actually became extremely profitable. This meant that the trust generated a lot of money through the 20% shareholding it had in the company, and so did Boardman himself through the shares that he had acquired personally. So everyone should have been pretty happy here. However, one ungrateful person, a beneficiary of the trust, decided that he would sue Boardman for the profits he got. Now the issue was whether Boardman was entitled to keep the profits on his own share or whether he was required to hold that profit on constructive trust for the beneficiaries of the trust. The House of Lords held that Boardman should hold the profits on a constructive trust for the beneficiaries of the existing trust, and therefore the money Boardman had to be returned to the trust. So despite the fact he had acted in good faith and for the beneficiaries and for the benefit of the beneficiaries who did very well out of this, the House of Lords recognised the importance of the principle they were applying. In other words, people in fiduciary relationships cannot profit from it. So Boardman had breached his fiduciary duty as an advisor to the trust. So although he was not a trustee, he had a fiduciary relationship with the beneficiaries as a result of his advisory position. So this case shows how strictly the court will apply the principle that a fiduciary cannot make a profit. The solicitor acted in contrary to the principle that a person in a fiduciary nature cannot make a profit, so he had to pay it back minus a generous quantum of merit, that is a payment, as the House of Lords recognised he had done a good job nevertheless. In other words, Boardman was entitled to some compensation known as equitable accounting for his efforts in spite of the imposition of the constructive trust. And consequently, even in the absence of any proof of fraud or unconscionable behaviour, the trustee will be liable to hold such profits on constructive trust for the beneficiary. And there's a duty on Boardman to avoid a conflict of interest. He's acting for and on behalf of the trust itself, or he's in a fiduciary relationship with the trust itself, and so he should have acted in that manner and shouldn't have been trying to make a profit himself, but merely trying to make a profit for the company. So even though he's done a great job here, he has to return the money on a constructive trust. Okay, so that is the end of this video. There's going to be a couple more videos on the duties of trustees. It's a very important topic. And if you have any questions about this particular video on the couple of duties that we looked at today, then make sure you leave a comment below and I'll get straight back to you. If you enjoyed the video, give it a thumbs up and don't forget to subscribe to my channel. Thank you very much for watching.